This is going to be a somewhat unusual talk. The title of the talk is, as you will see, speaking of computers, if I can get this one to work, the title of the talk is Implementing Originalism, What D.C.V. Heller Shows Us. There's, of course, been a big debate in the legal academy over the last 20 or 30 years about originalism, but whether and to what extent should courts look to the original meaning of the Constitution in making constitutional decisions. You may have heard echoes of this debate. It's been quite heated often, it's quite controversial. Not a lot to be said at the very general level about it now that so many people have participated. But it's always helpful to look to see how theoretical concepts play out in practice. It may reflect negatively of the concept, it may sound good in principle, but in practice it doesn't really work. It may reflect positively of the concept, it may be that as implemented it actually makes sense. More broadly, I think it's only through concrete application that we can understand legal principles, and especially high theoretical legal principles. That's one reason when I went to law school and philosophy. What I like about law is you have the cases. And it's not just a statement of abstract principle, it's application of that to the case. And only in the context of that application can we really figure out what's going on. So this is a talk about D.C.V. Heller and about the Second Amendment and about how the court has interpreted the Second Amendment. It's also a talk about originalism and about original meaning jurisprudence. It will therefore be somewhat unusual talk. I have PowerPoints, I think, they overuse PowerPoints at times. But one thing they tell you in PowerPoint is don't have too many slides and don't put too much text in each slide. I try to follow that rule, but I violate it here because this is in very large part a talk about rhetoric, a talk about arguments, and about the way judges make arguments, and whether that way makes sense. In the process, we'll see the particular arguments that they made about Heller. So if you're just interested in the Second Amendment as such, and that's it, that's fine. But we're going to be trying to pay a good deal of attention to the particular words that the justices used, particular arguments they made. So as a result, this is going to be pretty text-heavy talk. I also prepared what I'm sure is way too many slides, so you will at times see me skipping through a few because I don't know exactly what pace I'll be making. But that's one of the artifacts of having a custom written paper. This is an off-the-shelf paper that I presented a dozen times before. It would be a lot smoother. Here, we'll see how we progress. But I hope that one way or the other, you're going to get a flavor for both the particular historical arguments that can be made and have been made by the Second Amendment, who was right, depending on how you understand right in the court's case, and also about the way the court does originalism, the way it implements this theory, both in the majority and the dissent, which also, at least the Stevens dissent, which I'll be talking about, tries to be self-consciously originalist. So just a little bit of background. Remember, D.C.V. Heller came down earlier this year. It struck down the D.C. handgun ban. D.C. banned all possession, pretty much, of handguns. It required long guns, rifles and shotguns, to be locked up or disassembled. But the main focus was on handguns, and the court, in the 5-4 decision, the 5 conservatives and the 4 liberals, voted to strike that down on Second Amendment grounds. Now the court begins. Part 2, once it gets through all of that summary, we turn first to the meaning of the Second Amendment. The meaning of the Second Amendment. There's the text of the Second Amendment right up there. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Actually, even if you just glimpse the text, without even paying much attention to the meaning of the words, you might get a sense that there's going to be a non-trivial project going on. The first thing you might notice is the capitals are kind of odd, right? We wouldn't use capital letters there except for that A, right? Also commas. There's the 3-comma view of the First Amendment versus the 1 comma. Some people claim the original authentic version had only 1 comma rather than 3 commas. Apparently, I looked at the image of the original. It's pretty clear it's 3 commas. It's also pretty clear that people of that era didn't put much stock in it, and it is also clear that there's at least one of those commas is in a place where we wouldn't put a comma today. It's not that they were wrong. they were writing in the late 1700s. We're reading in the early 2000s. The words are still accessible, just like Shakespeare from a couple of hundred years before them is still accessible to us. But already, just the capitalization, just the punctuation should give us a signal that there may be a little bit more work going on. Both things we don't understand, and worse yet, things we think we understand but really don't understand. So let's get through this paragraph, because it actually signals a few very important things about the project of the court, at least the majority source sophistication, and clears up a few misconceptions about at least modern originals. First, Scalia says, we turn first to the meaning of the sentence. And then it says, interpreting the text were guided by the principle, the institution was written to be understood by the voters, and its words and phrases were used in their normal and ordinary meaning. Normal meaning may include an idiomatic meaning, we're going to see a good deal of that, but it excludes secret or technical meanings that wouldn't have been known to ordinary citizens. Once upon a time, in the 1980s, when originalism first got hit the public and hit the academy in a big way, the language of originalism is the language of original intent. You want to find out what the drafters intended, what did Madison, the lead drafter, and others intended. There's been since a pretty, in some respects, a subtle but very important shift. That almost all originals, not all, almost all originals now talk about original meaning, sometimes original public meaning. The theory is what was in Madison's head, and there's actually one of the early rounds of criticism of originalist jurisprudence was that the drafters themselves, there's some evidence that they didn't want people to try to figure out what was going on in their heads. They didn't want their understanding and their intent to control. They were creating law, and law has objective public meaning, which is the meaning in the legal language of the time. Note, when Scalia says that secret or technical meanings that wouldn't have been known to ordinary citizens are excluded, I don't think he means it's got to be just lay meaning. Ordinary citizens would be ordinary citizens of the class that would likely have had an understanding of the legal concepts of law. So original public meaning jurisprudence focuses on what the words meant or likely meant, we don't know for sure, but likely meant in the publicly accessible legal language of that era. So we look at the phrases, we recognize that some phrases have another meaning, and we try to figure out what they mean. But if we listen to what Madison said about it, or look at whatever debates there might be on the subject, we might look to them as evidence of what the meaning of the phrases were. But we wouldn't say, oh, Madison wanted this to happen, therefore we're going to take Madison's view on this. Because Madison was just one voter on this, very important voter, but just one voter. The important act being the legally significant, not the writing of this, but the enactment or the proposal of the Bill of Rights by majorities in the Senate and the House, and the ratification in the states. So what the drafters meant doesn't really matter that much. What matters is how it was understood by the ratifiers. So original meaning, and it could be idiomatic, but it can't be sort of secret, hidden, what was in their minds. Now the first thing that people recognize is that the Second Amendment has two clauses. And the court is going to talk about is the prefatory clause and the operative clause. So I just want to tell you, the prefatory clause is what sometimes some people call the militia clause. Not a great idea to call it the militia clause because there are also the militia clauses in the Constitution. So the prefatory clause, the operative clause is the right clause. In a sense, saying prefatory and operative already is a nice little rhetorical trick, which allows you to focus the reader's mind on, oh, that the operative clause, that's the one that has operation, the prefatory is merely a preface. But those are the labels that it uses, and it has to use them because there are these two clauses that are related to each other in a way that different clauses in other Bill of Rights amendments are not. So it has two clauses. And at the very outset, Scalia makes an assertion. He doesn't trust to defend, but it's a very important assertion. The former does not limit the latter grammatically, but rather announces a purpose. It's sort of could be rephrased as because a well-regulated militia is necessary for the security of the state, the right of people to keep their arms shall not be infringed. It's because, and as we'll see very shortly, that his grammatical structure also is reflected in its original legal meaning. That just as the former does not limit the latter grammatically, neither does it limit the latter legally. Then it says, although this structure of the Second Amendment is unique in our Constitution, other legal documents in the founding era, particularly individual rights provisions of state institutions, commonly included a preparatory statement of purpose, citing a 1998 law review. So a couple of things. One is, law professors get cited by Supreme Court. We have a whole slide on that. You can see it's very important to people like our profession. But there's another point that is important here, which is that note, when we'll talk later on, we'll see Scalia talking about the text of the amendment. We're going to see him talking about commentaries on the amendment. We're going to see him talking about the meaning of some of the phrases within the amendment and the like. So if you're sitting down and trying to figure out the meaning of the amendment, those are things you normally look to. But here, he's talking about the grammatical structure of the amendment, and he's alluding to other legal documents of the founding era, which actually are not right to bear arms provisions at all. They're in other constitutions, not the federal constitution. And there are other kinds of rights, not the right to bear arms. Now, they're still quite relevant. I think he's quite right to say that they're quite relevant, because they tell us something about the legal significance of this grammatical structure. If, in fact, the Second Amendment was unique, not just in the Constitution structure, but anywhere, then I say, wow, the framers of the Bill of Rights, the authors of the Bill of Rights, must really have been trying to do something very different with the Second Amendment. The fact that it's very similar in structure to lots of other provisions, some of which are also framed as freedom of the speech being essential to the security of freedom of the freedom of the press being essential to the security of freedom in a state, ... That's pretty important, but it's actually not trivial to find. And this article came some 20 years after people first started writing about the Second Amendment, about 15 years since things started appearing in top law journals about this, and 7 years after Sandy Levinson's article, The Embarrassing Second Amendment in Yale Law Journal, really put it on the map. So it actually took a while to identify this, and it turned out that this fact was found almost by accident. People of the framing era would not have been at all surprised, because they would have read the state constitutions at the time, and they would have said, well, yeah, obviously. But today, it's actually not trivial to find this. And this is not the linchpin on which the opinion turns, but it does highlight one possible difficulty with original meaning jurisprudence. And that's you've got to actually figure out what the original meaning is by figuring out how it was understood. The very different people in a very different time, people working under a very different set of legal documents. So it's the fact that this came up almost by accident, wasn't discovered until the debate was some years in process, may make us wonder what else have we missed. What if 20 years from now, somebody discovers some other documents, some trove of early court decisions or something like that that were never reported, never printed, never published, or at least never looked through by law professors, and it turns out they give us some other interesting perspective. I doubt that they'll give us a perspective different from the one we see based on the evidence we have now, but it's possible. So one of the things that's noteworthy is that sometimes, to do original meaning jurisprudence well, you've got to know, not just about this provision or about the debates about this provision, you've got to know about the way state constitutions were written at the time. You've got to know a lot. And maybe it helps that the court cited a lot of law review articles, but for some other topics, it may not have a lot of years of scholarship and a lot of articles written on the subject. And so if it's all limited to what the lawyers and the justices and their clerks can find in the course of litigation, it could be some important things got lost, as this might have been as well. So I promised you this slide, the most important thing in this. So it's interesting that last term, 29 cases out of 70 cases cited a law review article. Interestingly, Heller cited more than any others, 14 articles. By the way, I did this on the cheap. I just did a search to Lexis for anything that cites, anything that uses the words LRev, or LJ, or JL. So there may be some other law reviews, Leonard, or long contemporary problems, or such that weren't cited. I try to remove some of the false positives. But Heller did cite more than any other article, more than any other case. A little less than half of the cases had just one article. 7 cited 4 to 10. Interestingly, a lot of people are saying the legal academy is getting irrelevant. And one of the ways they say it is, it's irrelevant to judges. Judges are really important actors in this legislature. Stupid. I'm sure they don't read law review articles. Judges at least might read law review articles. They used to, but not anymore, because the legal academy is now dominated by postmodern claptrap. That's a common argument. Well, I will tell you that the citation rate by the Supreme Court, this is one data point, but also some tentative data I see from circuit courts seems to bear this out, is almost identical to the 1970s, 80s, and 1990s citation rates. And it's a little bit lower, so it's about roughly 40%. That's what it had been throughout. It's a little bit higher, excuse me, than it was in the early 2000s. But basically, legal scholarship does matter in certain situations. And I'm happy to hear that those of you who are law students thinking about either career in scholarship or writing your student notes, be emboldened. Somebody's still paying attention. Just a small fraction, of course. I'm talking about how many court cases cite articles. I'm not talking about how many articles are cited by court cases. That percentage is not an argument. All right, so returning to the opinion. Let's go through this, because again, there's a lot of stuff here on the slide, but it's actually pretty important. Because here is where Scalia is dealing with the main problem. If you think about it, Scalia has a big problem. That's the prefatory clause. Why in the world, if this is an individual right to bear arms, what are they talking about with this whole militia stuff? Stevens is a problem, but it's the operative clause. Why in the world, if this is just a militia right, what are they doing talking about right of the people? So both of them try to solve that problem. Or rather, I suppose, what happens is they read through the amendment, they come away with it through one particular sense of what it means, but then they have to explain why it means that their favorite clause dominates and not the other. So Scalia says, well, the prefatory clause may resolve an ambiguity in the operative clause, but apart from that clarifying function, it doesn't limit or expand the scope of the operative clauses. And he goes through and says, look, it's true we have to give meaning to every provision in the text. That's a standard canon of construction. But we have to give it meaning for its role. And prefaces should be given given the meaning that preambles generally carry, which is that they may resolve ambiguities, but they don't actually trump the meaning of the operative clause. And what's more, he cites an early, roughly 1800 source for saying there's nothing unusual for the enacting part to go beyond the preamble. The remedy often extends beyond the particular mischief which first suggested the necessity of the law. Now, as we will see later on, Scalia works very hard to explain why there's actually not that much tension between those two. I'm sure he sincerely believes it, but it's quite clear. Believe it or not, as a lawyer, your job is to argue that all the sources point in your direction. Not that one source points in your direction, the other one in another. Yours is better. You want to argue whenever possible all of them point the same direction. But sometimes you have to say, look, this is the one that's most important. And he argues it is the operative clause that is more important because it's operative. Because it's not just the preamble, and because there's this tradition that contributes to the original public meaning, that is the operative clause, the clause that talks about the right and what it is a right to and whom it belongs to, that is controlled. Now let's walk through this a little bit. The right of the people to keep and bear arms. That's the first. Sorry, that's not the first. That's the first part of the operative. So he says we begin with the operative clause because it's operative, then we'll go back to the preamble and check to see if it's consistent. It's an important check and make sure we didn't err on in our understanding of the operative clause. So looking through this, let's look at the first one, the right of the people to keep and bear arms. So this is an interesting thing that only recently acquired a label, Kiramar, some years ago, labels it this intratextual. And it's a very important aspect of all meaning interpretation, especially original legal interpretation, which is when you see the same terms in the same document. There's a very powerful suggestion that those mean the same. So Scalia says, look, the right of the people is not isolated in the Second Amendment. If it were only the right of the Second Amendment and everywhere else it said the right of a person, let's say, that might give us a sense there's something collective about this. But it does talk about right of the people. In the Assembly and Petition Clause, in the Search and Seizure Clause of the Fourth Amendment, in the Ninth Amendment, the right of the people. All three of these instances unambiguously refer to individual rights, not collective rights, or rights that may be exercised only through participation in some corporate body. Aha! That's what that particular provision means, or that particular aspect of the provision means. How do we know this? Because we have cross-references within the very same document. Now, it's interesting, we have other references to the people. Three provisions of the Constitution refer to the people in a context other than rights. The preamble, we, the people of the United States. Section 2 of Article 1, which is that the people shall elect the House of Representatives. And the 10th Amendment, which talks about powers reserved to the states and the people. So he says, well, those might refer to acting collectively. But that's the people. The people could be collective, but the right of the people, at least in the federal constitution, that's always about individual rights. Some early state constitutions use the term that people refer to people collectively, but that usage wasn't remotely uniform and it wasn't clearly not the terminology used in the federal constitution. And here, you remember, he did look at state constitutions in other contexts, and he will again. He looked at state constitutions in looking at the two-clause structure. And there he thought it was relevant. Here he thinks it's not. I think he's probably correct that the right of the people is several times and pretty unambiguously used in the federal constitution, and that's pretty powerful evidence. The two-clause construction doesn't appear in the federal constitution. That's not much evidence of anything at all. And when we look at its use in the state constitutions, that's helpful here in a way that the state usage of the people is not. But it just shows that sometimes we can treat the body of framing era law as this corpus of information about what legal terms meant at the time. But we shouldn't delude ourselves into thinking that they used it super duper precisely. You know, they're written by different people, they're written somewhat different times, they're written by people who sometimes make sloppy mistakes. So there is going to be some uncertainty in a lot of these kinds of judgments. Interestingly, he says all 6 other provisions of the Constitution mention the people. The term unambiguously refers to all members of the political community, not an unspecified subset. That's actually not completely clear. One of these provisions, Section 2 of Article 1, which talks about the people elected to the House of Representatives, it's quite clear that it wasn't all the people who were doing it. And in fact, it specifically says the electors for the House of Representatives would be those people who could elect the most populous House of the state legislature. Universal suffrage, or even universal suffrage for adult white males, was not at that point at all settled. There was a movement towards it, but it was not at all settled. So in fact, actually, the people who elected the House of Representatives under Section 2 of Article 1, really, that power was exercised through a subset, which is to say the electors. So not clear if he was quite correct here. I do think he's right, though, about the right of the people. Now, Stevens wants to argue differently. And here he, too, as I mentioned, the natural tendency for any lawyer, including a judge, judges first and foremost are lawyers, is to try to make everything point in your direction. Lawyers sometimes, I think, tend to overclaim some things. Here, I think he may have done so. He says, well, actually, the rights of the people aren't necessarily individual. They could be collective. For example, the right to petition the government for redress of grievances, but especially the right peaceable consent that contemplates collective action, protects individual rights, but concerns with action engaged by members of a group. Likewise, petitioning is only effective if you've got a lot of names on your petition. I think that's pushing things a little far. I suppose the right to marry is well recognized by the court as an individual right, but it takes two to tango. You have to have collective action in order to marry. That doesn't at all affect our understanding as an individual. Even the right to freedom of speech, in a sense, the quintessential individual right recognized by centuries of legal understanding in America, you have to have a speaker and a listener for it to be at all effective. It's not just a petition that requires collective action, it's speech as well. But it's pretty clear it's an individual right. So the fact that in order to assemble, you've got to have a bunch of people, it's not at all like the collective power of the people to elect representatives. That really is something that is a collective institution and is treated as a power in the heart. I think that Scalia has got the better of this argument that the First and Fourth Amendment and Ninth Amendment rights are of the people as individuals. Then he moves on to talk about the right of the people to keep and bear arms. We're back to Scalia. And he says, look, arms is pretty clearly weapons. It's not just military weapons, it's weapons. That's an interesting question. Is arms clearly just the kinds of weapons that you would use militarily? Is it even just military weapons, period? Or does it mean something more broadly? And he points to what I think are pretty persuasive array of sources that says, well, arms could include essentially any arms that are used for offensive or defensive uses, whether or not they're specifically designed for military uses, and whether or not they're employed in a military capacity. In a sense, it's like if people talk about assault weapons and other military-derived weapons, there's something of a fiction in thinking there's too clear a line. almost all weapons are military derived in some sense, because the military had long had the most solid need of them, and many civilian weapons are just indirect versions of them. But it was pretty clear at that time that there were weapons you wouldn't use in the military. A blunderbuss you wouldn't use, and others that were quintessentially military. He, I think, makes a good argument that, based on contemporaneous sources, that arms were military, were non-military as well. But here's the important thing that gets beyond this. Why do we want to look at those sources? Why don't we just say, well, what does arms mean today? Well, one possible answer is even today it's not completely obvious what it means. But at least not kind of in an intuitive sense, though I suppose we could look at the dictionaries in a similar way. But the other part is, if we're following the text, and there's a phrase like arms, or as we'll see shortly, keep arms and bear arms, it's hard to see why we would use something other than the meaning that was within the text as it was understood at the time, and instead use something that may have just be almost a pun based on changes over the last couple of hundred years. And I think the best example of this, to understand this, comes out from the second over the seventh. What is the seventh? I'll bet you thought there were no questions to do.
Civil jury trial?
Civil jury trial. Is it in all cases?
No, only law.
Only in cases arising under the common law, also only in excess of $20. In suits at common law, the right of trial by jury shall be preserved. Now, the common law has at least 4 different meanings. Common law could mean, and today often does mean, and even at the time probably meant in some measure, non-statutory law, right? You could have a common law torts as opposed to statutory causes of action. It could mean that. So therefore, you might say that you have to have a right of trial by jury if you've got a libel lawsuit under common law tort, but not if you've got an employment discrimination lawsuit that arises under statute. Or even a libel lawsuit that arises under a codified tort, because then it's no longer common law. Or you could say common law is law that's originally judgment, even if it's not codified. For example, in contracts classes, criminal law classes, we always talk about it. There's common law approach and the model penal code approach. Never mind that the common law crimes have been codified in every state. Still, we call them common law approach because they were originally designed by judges, even if they're later codified. So this could mean that. So again, in that situation, if there's a lawsuit or a libel lawsuit, it doesn't matter if libel law has been codified or not, then you've got a trial by jury there, but not if you've got a Title VII lawsuit, a discrimination lawsuit. Common law could also mean Anglo-American law, right? We talk about common law countries versus civil law countries. So therefore, if your lawsuit is under a contract that calls for the interpretation, calls the application of American law, then you have a jury trial. But if you've got, or English law, you have a jury trial. Of course, a contract could call for application of foreign law. Many international contracts do. But if you've got a contract that calls for the application of French law, then you don't have a jury trial. Because after all, it's not a suit of common law, it's a suit of civil law. You could say that. It's not ridiculous given the text of this. Or it could be that common law is a body of law traditionally enforced by courts of law rather than courts of equity. Actually, if you talk to an ordinary layperson, you may say, I have no idea what common law means. Or if you push him, yes, he might actually remember the America common law jurisdiction, France is civil law. Or you may say common law, that's not statute. So you could say that. What is the interpretation that is now given to the Seventh Amendment? Which one of these 4? 1, 2, 3, or 4? 4, there's no doubt about it. That's what it means. Why is that what it means? It means that because, actually, let me say that. The reason we care about, the reason we do that is because we're trying to apply the text. It's not like some matter of basic natural law principles or fundamental human rights or whatever else. We say there have got to be civil jury trials in federal cases. No, there's a text, there's a constitutional rule we're trying to apply. And why are we applying it? Because once upon a time, 200 years ago, a bunch of people made it the law, and now we've got to apply the law. When we apply the law, we want to apply it the way it was understood by those people whose actions, not by the individual people, but by people of the era of their edification. That to the extent we apply it because it's binding law, we care about what it meant at the time it was enacted. So that's a not terribly controversial example of that. But what it suggests is that being an originalist is very close, or is almost necessary, not quite necessary, but almost necessary if you're going to be a textualist. If you're going to be an evolving constitution person, you don't have to be originalist, but then you can't really focus too much on the text either. Because if you want to talk about evolving constitution, it makes perfect sense for it to evolve beyond the text as well as beyond the original meaning. But if you're going to be a textualist with the Seventh Amendment, it's hard to see any answer to the common law question other than figure out what common law meant. It's a bit of legalese, and we shouldn't let our changes in common understanding turn essentially work upon into the text of the amendment. So likewise with arms. He then goes on to actually let me skip this for now. Goes on to keep and bear arms, and there's a big controversy on this one in the debate about whether keep and bear arms means military again or self-defense. And Scalia begins with keep arms. Not surprisingly, because that's the self-defense, the most clearly self-defense movement. And there are actually lots of examples of how keep arms has, in this kind of context, a self-defense connection. It's not like you can't keep military arms, but you can also keep arms for self-defense. And there are lots of references in both gun laws of that era, the banning the keeping of arms, keeping of private arms, and in discussion of protections, so talking about people's right to keep arms. Justice Stevens dissents, and he says, well, no, you could keep the arms for military purposes, and you could bear the arms for military purposes. So we've got to look at keep and bear arms, because he's going to talk about bear arms specifically as a military notion. We're going to look at keep and bear arms as a joint right. So to him, that is one of those idioms. It's an idiomatic concept. To keep and bear arms is something that is purely military. As we'll talk later on, especially when we get to the elephant, that ends up being working into Stevens' argument. You can decide for yourself whether it makes sense. So bear arms is another situation where there is a good deal of ambiguity about what bear could mean. As I mentioned, it could be, there's no doubt, and Scalia is not denying it, that bear arms had an idiomatic meaning, which we'll get to shortly. And that meaning is to serve in the military. So, for example, somebody could be a traitor for bearing arms against his country, against his son. You have the duty to bear arms in certain kinds of situations in the sense of serving in the military. But Scalia says it also has a self-defense meaning. And again, here is something where he goes through and cites various sources. Let me tell you something else about the difficulties of finding a lot of these sources. You might ask, how is it that people found the statute law of Scotland had breached? Were there kind of Scots law scholars that took an interest in the Second Amendment? Or did somebody sit down and just read all of the laws of the time? Maybe they would have the laws, but how did they find Vattel? How did they find all these other things? The answer is on the cheap, and that is by doing electronic searches. Now, a very great many books written in the 18th century, and a very great many treatises written in the 19th century, and newspapers published in the late 1700s. All of these things, they are available on the internet. They're not available for free, but most serious university libraries have subscriptions. So what happened was some people, either the clerks or the parties or professors, sat down and did searches, search for bear arms, search for keep within 3 of arms, and they found all this stuff. Good for them, good for the court if it's trying to do original meaning jurisprudence. Interestingly, suggested that this case had come up 30 or 40 years ago. Maybe none of this evidence, but much of this evidence wouldn't be available. Which makes a funny thing, that maybe, in fact, original meaning jurisprudence is doable now, because we have access to all the original sources. But it wasn't doable for much of the history of the US, because even if it's a matter of fundamental political and moral principle, the way you should do things is through original meaning, it just would be very, very hard, prohibitively hard for you, unless armies of professors have been working for a long time, to actually figure out the original meaning, because all the sources of, again, unless you're extraordinarily learned, they're not ones you would have read cover to cover, and that's the only way you could have found them. So maybe that's a reflection on original meaning, that it's great to have this kind of original meaning, but for a long time it didn't seem possible. Maybe we've lucked out that it's possible now, but it would have been a difficult thing in many respects to do just a few decades ago. So actually, again, let me skip through this because I want to move on to this. What do we have right now? So we've got the people, which Scalia, I think, quite plausibly says is generally, when said, right of the people is individual right. We've got arms, which could be military arms, but certainly could include could include firearms. We've got keep arms and we've got bear arms. And bear arms has an often military meaning that has also a non-military meaning of just carrying for offensive or defensive purposes. We've got keep arms, which is generally used for non-military context, but could be for military as well. Naturally, as I said, Scalia focuses on the keep. Stevens focuses on the bear, but they want to try to make them make sense. And one of the things that then comes up isn't just whether Scalia's approach makes sense or Stevens' approach makes sense, it's which one makes the most sense. And Scalia says, aha, I think I've got to get to rights. Because even though there is an idiomatic meaning of bear arms, then that is a meaning that isn't going to work. Because you can't have a right to bear arms in the sense of a right to serve in the military. That would be a very strange thing to have. Serving in the military may be a duty, maybe something a lot of people would like, but it's a very rare thing to be seen, a very odd thing to be seen as a constitutional right to actually, not just serve in the military, but actually be sent out into battle, let's say. That's a strange thing to have a right to do if you're physically incapable, or if you're just not very good at it. So instead he says, look, Justice Stevens isn't using the idiomatic meaning. He's using a special meaning that bear arms means not just serving, but actually carrying arms in the service of an organized militia. So he says, look, the meaning that Stevens proposes isn't even really a meaning that is the it's a custom-made gerrymandered meaning just for his proposal. It doesn't work. So I'm going to skip the Zugma slide. Well, if you're curious about it, I'll get to it later on. So let me just move on and talk a little bit more about a couple of other things and get to the militia clause, and then I'll skip over it. I mentioned a lot, but I'm happy to talk about it and talk about more in the Q&A. But I want to talk about a couple of other things. So we've seen Scalia and we've seen Stevens in dissent go through the individual words and the individual phrases and try to figure out what they mean. And this is a pretty standard, I shouldn't say standard approach. Among other things, it becomes easier only recently with modern research. But what you do is you kind of look at the Constitution and look at other sources as kind of, if not quite dictionaries, but as what a linguist would call corpuses, a body of usages of terms that allow you to figure out what the terms mean in different contexts. So people means one thing, keep arms means one thing, bear arms means another. But then he says it's not just about that, although that's the most important thing to look to. We also want to look at the historical background of second, although not to confirm it. He says the first thing we do is look at the text and follow after the original public meaning. But we should look at the historical background to see if our conjecture about the text makes sense. Because if it reads something that makes no sense in light of history, then we'll go back over and see what we got. He says, aha, fortunately, by happy chance, it is actually strongly confirmed in the historical background. That there were the disarmaments by the king in the 1600s that led to the English Bill of Rights provision. Later on, he also says about how there were disarmaments in the 1700s in the colonies that the colonists were very upset about. And that when you talk about the English Bill of Rights provision and you talk about state constitutional framing era rights to bear arms, those are all parts of the same provision. And this is another place where Scalia and Stevens actually very much disagree. And again, here I think Scalia has the better of the argument. Stevens says, look, the English right to bear arms and the state constitutional right to bear arms are actually very different. The English Bill of Rights may have been individual. It have to be that because it couldn't have been a states' right. There were no states in England. And it was treated by Sir Blackstone, who was the expositor of English law at the time and also very major influence on the framers. The right was treated as an individual right. He says that's a different right. That's a different right. So Scalia says, no, if you've got the right to bear arms in America, in the federal constitution, you've got the rights to bear arms, many of which, although not all of which were as clear, but many of which were clearly individual rights in state constitutions. You've got the right to have arms in the English Bill of Rights. They've got to be part of the same thing. To Scalia, much of the Bill of Rights, not all, but much of it is declaratory of long-standing, understood, pre-existing English legal rights. And that he does have a good deal of history and also precedent on this. That's where Stevens disagrees because he must for his position to be sound. And that's another major point of disagreement. So then, of course, they have to go back and look at the first clause because Scalia acknowledges there's some importance to the first clause. And he again goes through much of what we saw in as to the second clause, that points out militiamen. It turns out it wasn't a National Guard sort of select subgroup type body. It was more an armed citizenry. Well regulated, he points out, I think again quite correctly, meant the properly disciplined and trained rather than mounted. And he ultimately comes to the conclusion that, I'm sorry, one of the things, security of a free state, he also says is not a state's right condition, only security of a state from the federal government, but rather security of freedom in a country. And he cites some sources. He also cites a law review article that actually went through, again, the cheap way by going through a whole bunch of electronic searches to find how free state was used by the authors that the framers read the most, like Blackstone, Montesquieu, the authors of Cato's Letters and the like. And makes what I think is quite persuasive argument that ultimately, that ultimately this clause 2 is in fact consistent with the operative clause in recognizing the right as an individual. But, and this is what a lot of the commentaries on the court's decision missed, is there are two debates that could be had here. One is individual right versus states' right. And even Stevens in dissent says, oh, this is an individual right, although I'm not sure he really means it. And there I think Scalia is absolutely right. All the evidence that we've talked about so far, we just touched on it, but you can go into much more depth. All that evidence very strongly suggests that the right is an individual right. But if it's an individual right that is only aimed at the deterrence of government tyranny, at the maintenance of an armed citizenry as a deterrent of government tyranny, it could have a very different scope than an individual right aimed at self-defense, and in a way that's very important to have. Not that it would only be a right that would belong to people authorized by the government to possess guns. That would defeat its purpose as an individual right. But because the guns that would be most likely protected would be long guns. Those are the standard equipment of a soldier. They might even be fully automatic guns, although Scalia wants to back off from that. But they probably wouldn't be handguns. In this case, it's mostly about handguns. So here's where Scalia makes his next move. What he says is that the prefatory clause announces the purpose for which the right was codified was made constitutional. But it does not suggest that that was the only purpose for the right, nor does it limit the scope of this pre-existing right, which was a self-defense right. And there, I think he's probably correct, but this at the very least is much, much more controversial. Because while it's true that the pre-existing right, the right to keep and bear arms, the right to have arms, as Blackstone was talking about, was aimed both at maintaining armed citizenry and at individual self-defense. One could say that the prefatory clause does clarify, specify even a little narrow the meaning of the operative clause, to say, well, the only individual right that there is an individual right to possess military weapons rather than civilian self-defense weapons. And Scalia says, well, the prefatory clause announced only the purpose for which the right was codified, not the scope of the right. But it's not ridiculous. Even the people who think the preamble can only clarify the operative clause and not completely eliminate it. It's not ridiculous to say, well, the preamble clarifies that the operative clause secures one part of the pre-existing right, the right to maintain, individual right to have arms as a deterrent to government tyranny, and not the individual right to have arms for deterrence. So that turns out to be a very big part of the debate, and probably the part that I think, part of the opinion that should be the most controversial. I'm going to skip over a good deal and focus on a couple of important things. First, so I think we've laid out what it is that how it is that Scalia interprets the right to find an individual right of the people, generally understood in the Constitution as an individual right. It's a right that's not limited to the military context, to keep arms and to bear arms, referring, he argues, to civilian possession as well as military possession. The well-regulated militia clause simply refers to one reason why the right was codified, which is to preserve the armed citizen in well-regulated militia, not for the security of a state free from federal interference. That too, he would say, that's a pawn, play on what we free state may mean to people today. At the time, it meant security of a free country, security of freedom in a country, security of America as a land of liberty and states and countries. But afterwards, I told you, we're talking about implementing originalism. And the one thing that originalism doesn't really tell you is, what do you do about a waiting period? What do you do about assault weapons? What do you do even about a handgun ban? Even if there is an individual right, the question is, first of all, is it absolute? That originalism may tell you about. Well, what is the exact scope of that right? And that's something that we don't really get to see much of, for understandable reasons. But still, for reasons that tell us what the limits of originalism might be. So, as an originalist matter, I think Scalia is right that the right was not unlimited. I think the framers generally saw substantive rights as not unlimited. And there certainly is lots of authority from that era, so suggesting, both as to right to bear arms and as to other rights. So he says, well, there are certain categories that are, in fact, excluded from it. And he just lists them. There's actually a lot of sites with a lot of sources. All of this textual interpretation and cites the 1700s treatises and the like, none there. And a lot of people criticize him for it. I think what he's driving at, though, is something he's talking about elsewhere, and that actually distinguishes some measure Scalia from Thomas. Scalia and Thomas are both thought of as originalists, but Scalia, in addition to talking about original meaning, also talks a lot about tradition. And tradition in him has two roles. One is tradition is evidence of original meaning. That he would say, for example, with regard to laws regulating or prohibiting possession of firearms by felons, he might say, well, look, if those arose beginning in the 1800s, I'm not positive of the exact history, but those in the beginning of the 1800s, that was still within spitting distance of the framing in some measure. Certainly true of concealed weapons laws, which arose in the 1810s and 1820s. Spitting distance of the framing, the people there had a better sense of the legal environment at the time and the original meaning, and that, so therefore, there was evidence of original meaning. But at some point, this kind of original meaning evidence runs out, especially laws forbidding the carrying of firearms in schools and government buildings. Not a lot of stuff you can link back to 1791 there. So to him, tradition has independent significance. That he says, well, American people would generally not come up with traditions that are inconsistent with the Constitution, but it doesn't really tell us much about the original meaning, because most American people don't know that much about original meaning of some of these clauses. Rather, he sees tradition as an independent source of authority. And he doesn't talk about it here, but he's talked about it in other cases. So when he's saying this, I think what he's saying is traditionally recognized limitations are generally considered permissible. And innovations, something Scalia has no love for in a lot of areas, innovations, that is what the Second Amendment requires. Then he goes on and tries to apply the Second Amendment here. And one interesting thing is that he hints at another area where some restrictions might be permissible. Because one of the arguments he deals with is the handgun ban is not really a prohibition or an infringement of the right to bear arms. You still have all sorts of other arms you can keep in there, rifles and shotguns. And he says, well, handguns are really very useful to self-defense. There are lots of ways in which you can, this is the next slide. There are lots of ways in which you can lots of reasons you may prefer handguns for self-defense over, say, a shotgun. And therefore, this ban is really a ban. It's not just a regulation, it's really a ban. A lot of debate about assault weapons, for example. Assault weapons restrictions, which I generally find to be not terribly, in fact, I find it to be quite foolish in many respects. But for the same reason they're foolish, which is that assault weapons are really not much different from other kinds of semi-automatic guns. Also, this very logic suggests that those restrictions may be constitutionally permissible as well. Because while there are many reasons a citizen may prefer a handgun for home defense, there are very few reasons why a citizen would prefer an assault weapon for self-defense over a virtually identical long gun or short gun that is not an assault weapon. So one other possible area of permissible restriction are restrictions that put it in the language of other provisions, or the law of other provisions, don't impose a substantial burden on the right. That maybe certain kinds of restrictions are constitutional because there are really no reasons why the restricted gun or the restricted activity is necessary for self-defense. Let me now skip on to the last two slides because I've already gone a little over and I don't have time So Justice Stevens goes through a pretty long discussion, mostly focused on the drafting history and his understanding of the zeitgeist of the time. That what they were really after, what the drafters were really after, was after preventing standing armies and preserving the state control over militias. And he makes a lot of arguments, again, and we haven't had much time to talk about them. I don't find them to be that compelling, but they're interesting arguments. But at the end, he closes with the following trope. And I think it illustrates a couple of things. First of all, I think it illustrates the limitation of his argument. It also illustrates one thing I teach my students, which is if you come up with some really interesting and colorful allusion or a reference to a song or a movie or a saying, try to avoid it. Because they have, these another figurative usage, which maybe I should avoid, they have an attractive nuisance that quality. And what they do is they suck us in, not because they're good for us, and not because they're exactly apt, but because they have this charisma, they have this elusive quality that makes them seem fun. So they use them because they're fun even though they don't quite work. So remember, Scalia goes through all of these different provisions and says keep arms means this, bear arms means this, militia means this. Here's what the result is. And Stephen says this is just like the blind man and the elephant. In the parable, each blind man approaches a single elephant, touching a different part. Each concludes he's learned his true nature. One touches the leg and says it's like a tree. The trunk, another says it touches the trunk and says like a snake. But each of them, of course, has fundamentally failed to grasp the nature of the creature. What's wrong with this analogy is Scalia isn't like one of the blind men. He's like all of the blind men put together. He touches the trunk, he touches their arms, he touches the people, he touches all of those things. So he really is all the blind men put together. On top of that, if you had all the blind men put together talking to each other and trying to figure it out, and they touched not just the extremities but also the connective tissue in between, they might be able to figure out themselves. What's more, if they're blind, as all of us are in some sense in dealing with this stuff, they're doing really all they can do. If you have some capacity to get some sort of inspired gift of sight and just figure out that it's an elephant, you open your eyes and it's an elephant, that's great. And maybe, but Stevens is just as blind as Scalia is because he's not from 1791. He can't tell us what it meant at the time. They're all equally blind. Really, all they can do is what Scalia was trying to do. It's true that Scalia just said, it's all about their arms, and that's it, and that's all I'm going to talk about. He would be like one of the blind men, but he really is like all the blind men pulling together the resources, and unless you really do believe that you've got the answer that goes beyond somehow looking at the individual components of the text, it's hard to see why you're going to do a better job. And not just unless you believe it, and you're right. It's hard to see why you're going to do a better job than the blind men working together and trying hard to figure things out. Let me close with the majority's conclusion and with one other criticism. So the majority says, look, we're aware of the problem of handgun violence. We take seriously concerns. Constitutional use of DC with a variety of tools of combating the problem, including some regulations of handguns. We're not absolutists. We're not saying no gun restrictions at all. But the enshrinement of constitutional rights necessarily takes certain policy choices out. These include the absolute prohibition of handguns held in use for self-defense in the home. Undoubtedly something the Second Amendment is outmoded, but it's not the role of this court to pronounce the Second Amendment extinct. So one thing you might ask is, what would the framers have thought of this? You might say we shouldn't care what the framers have thought of this. But we might ask, what would the framers have thought of this? And I think the answer is, it depends on the framers. And I'll give you an example of a framer who actually, from his writing, seemed to have been a pretty substantial proponent of individual gun ownership, Thomas Jefferson, who might have been appalled. He might have said, my God, we fought a war. We fought a war. Why? To be independent. To be independent of people across the ocean who are governing our fate. To allow us to govern our fates ourselves. And you, even though you don't have to fight a war, you haven't declared your own independence from us. You're much further away from us than we ever were from England. Between us and England is just some thousands of miles of ocean. Between you and us is hundreds of years. Not only has the world changed and guns changed, but you've changed. You're different. You're not us. So why should you be governed by our head and hand? And I say this about Jefferson because Jefferson famously talked about how constitutions should have been or should be reenacted, redone every 20 years. Because every generation should set up its own rules. And there's a very credible case that all the stuff we've been talking about, also the justices have been talking about, while very interesting historically, is not the sort of thing that people should do. People should decide, as Justice Breyer, who's the same we haven't talked at all about, because it's not originalist, talks about we have to figure out what makes sense, and actually that makes sense to have the legislature decide what makes sense. What makes sense to deal with all these problems that are facing us. It's a perfectly credible position. And at times I wonder, people talk about dead hand control, but that's not an objection to originalism, that's an objection to constitutionalism. It's an objection to having a constitution that was written 200 years ago that is binding on us. Even living constitutionalist justices presumably are bound in some measure by the text. Maybe Jefferson would say, throw off the shackles, throw off the law, have a new constitutional convention. If you want to reenact the right to bear arms, do so, make it clearer, make it more suitable to your time. So that was Jefferson. Madison? I don't know what Madison would have said. I do think, though, that a lot of people of that era, to the extent they saw the Constitution as law, would say it's good that the people today are trying to follow the law. And the original meaning, it's not that it's important that they follow what we thought, but it's important that they follow the law. And when trying to figure out what the law is, you want to figure out how the law was understood at the time the law was made, so that you don't have the law change as a result of a pun, as a result of an alternative meaning that has become more common, not for legal reasons, but just because of a drift in people's understanding of the term. So I think on balance, I think I would have been happy that both Scalia and Stevens were trying to do the job. I think they probably would have agreed more with Scalia than with Stevens. But I think what they would have liked is that both the majority of the dissent spent a good deal of trying to figure out what the law is. And what the law is with an eye, not just towards policy, although Breyer does talk about that in his four justices said, but with an eye towards what the Constitution and its words mean today and what they meant then. So with that I close, and happy to turn over to Q&A.
Professor Volokh has agreed to take questions. We have maybe 10 minutes, so yes, sir.
Was there a discussion in the opinion as to the definition of arms as equating arms with firearms, or is it broader? Does it apply to all sorts of weapons? I noticed that one definition from Cunningham, the legal dictionary, talked about bows and arrows. Does it apply to knives?
Yeah, the answer is the court didn't have much occasion to talk about it, but the answer, I think that the logic of the court decision is exactly ties with that. There was some discussion in some of the 1800 state constitutional cases, I'm trying to find if I have something more closely on point, but I don't think I do, about this question that rejected some non-firearms on the grounds that they're not military enough. I don't think that fits in the code definition. I will tell you, in the state of Oregon, there's a considerable body of state constitutional case law having to do with state right to bear arms. And there are cases involving knives and billy clubs. And the court said, look, it is our right, in Oregon it's perfectly clear, as in most states, that this is partly self-defense, right? If these are weapons you could be using for self-defense, they're weapons that are presumptively protected.
Yes.
Just what have we accomplished with the recognition of authority to regulate in the individual right versus the community right? Washington, D.C. just repealed their law and reenacts it and says we've solved that. Mayor Bloomberg basically sticks his finger in the air and says the decision is wrong.
Mm-hmm.
What have we accomplished?
Well, so Scalia would say, what I've accomplished is I follow the law. And Mayor Bloomberg doesn't want to follow the law, well, at least I'm true to my oath. And if he's not true to his, then let him litigate. I think also if somebody says, well, but why didn't you, well, what's the point of your creating such a narrow right? He would say, one thing he'd say is, my job isn't to create broad rights. My job isn't to create rights at all. My job is to recognize the rights as I understand them. And in fact, the framers, as he mentioned I think quite correctly, were quite open to a wide range of regulation. I would say, though, that he would say quite correctly that the right is not so narrow after all. So DC is trying to reenact certain kinds of handgun controls, and some of them I think are mighty silly. But it is pretty clear that they have to allow handguns to be possessed, at least of some sort. They may be able to ban semi-automatics and only revolvers. Again, I said I think that would be a silly rule that we've been talking about that. But boy, that is more protection of an individual right to bear arms. And quite possibly that's all of the framers would have thought that had to be protected. Relatedly, as to New York, it takes litigation to get rights enforced. It's not enough to take a Supreme Court decision. At this point, we're not even sure whether the right applies to state and local governments, because that's, of course, the incorporation question, so the Second Amendment would be incorporated with the 14th Amendment. That would probably be the next big Supreme Court Second Amendment case.
If the, if we're talking about what kinds of weapons can be prohibited, why isn't the correct rule that people have a right to bear the kinds of arms that would be useful in military service, rather than to say the type of weapons that are useful for self-defense?
That's a great question. And Scalia tries to talk about that, and it's not at all clear to me that he's entirely persuasive. Some people say what the justices sometimes do is, Randy Barnett talks about, is faint-hearted originalism. That they try to be originalist, but when it comes down to some result that they don't really like, then in that case, they just blink. Or you're not even one that they don't really like, but they feel the rest of the Republicans, and they blink. And they give you a pale shadow of true originalism. Maybe faint-hearted originalism is better than none. Maybe faint-hearted right scope is better than no scope for the right. Here's what Scalia says. He says, look, it may be objected that if weapons that are most useful in military service may be banned. And the reason he says they may be banned is that it was understood at the time that what people would bring to the militia service is the standard civilian armor that they would possess at home. Pretty quickly they recognized they had to standardize weapons and couldn't just rely on home-owned arms. But at the time it was pretty clear that the kind of gun you used at home to defend yourself or to go out there and shoot game is the kind of gun you bring to militia service. He says, well, if that's true, and weapons that are most useful in military service may be banned, because there is this historical exception to the right to have arms for arms that are unusually dangerous, then the Second Amendment right is completely detached from the prefatory clause, because that doesn't really contribute much to the security of a free state. It may well be true today, he says, that militia to be as effective as militias in the 18th century would require sophisticated arms that are highly important in society at large. But the fact that modern developments have limited the degree of fit between the prefatory clause and the protected right can change our interpretation of the right. So he says the right was always, you have the right to have the kinds of the standard non-unusual, non-dangerous weapons that you have for kind of home defense. During peacetime, you can bring them. It's true that today, that's not going to protect the security of a free state much, but that's all you can. That's his answer. Query whether it's satisfactory.
Yes.
If you have the right to bear arms under the Second Amendment, where is the restriction on the use of that arm?
Well, that's also an interesting question. There's some discussion of, but I think there isn't much because I think it was pretty clear that the right to have arms, while related to the body of self-defense law that existed, let's say so permissible to keep people in self-defense and such, was not defining of it. It was a separate body of law. So you have the right to keep and bear arms, like you have the right to have arms, but you can only use them in ways that are lawful. So you can't use deadly force to protect property against larceny, as opposed to say robbery or burglary in most states. I think that the Second Amendment was never understood, and none of the other rights were understood as dictating the scope of self-defense law. It presupposes the existence of some degree of self-defense law. It's possible if the legislature wanted to abolish legal self-defense altogether, which I can't imagine the legislature doing, that would run afoul of the implicit presumption behind the Second Amendment. But if, for example, the question should be a duty to retreat outside the home when you can safely in order to avoid using lethal force, or whether you can use lethal force to defend property, I don't think the Second Amendment or state constitutional rights to bear arms directly speak to it. Oh, there was a
Right. Did you see Boston Legal where Allen defends Denny Crane on this very issue? And you're back to the two clauses. He did a good job, Allen does, in there explaining how Scalia just took the first 13 words out of the Second Amendment clause out of the Constitution.
Well, I like Boston Legal because I was actually once mentioned on Boston Legal. There's a character, like I said, like a guard, a nighttime security guard, who one of the other characters gives money to because his child was sick. It was named Eugene Volokh, because that's how you get paid for consulting with friends of yours on legal issues. Comes on with a different episode. So I'm all for Boston Legal, but I think on this story, I didn't see that episode, I think that Scalia talks about this and tries to respond to that, I think, effectively. He says, first of all, that the preambles, they're not supposed to be read out of the text, but they are preambles and to be treated as subsidiary rather than operative, which is what the operative clause And he says ultimately the operative clause in the preamble fit pretty well. They don't have to fit perfectly. That was the quote that I mentioned, that there's nothing odd about a preamble, about an operative clause going beyond the justification offered by the preamble. They don't have to fit perfectly, but they have to fit in some measure, and this one does. The well-regulated militia is the armed citizenry. The people are the citizenry, or the public at large. The security of a free state includes security of freedom and not just security of a state against the government. So that fits with the individual right as well. As I said, the one difficulty is you could say, look, that's all well and good to say the right is still individual and not just for members of the militia, it's the right of all the people. But still, the first clause does limit the purpose of the right and therefore its scope to include, for example, only rifles and not handguns. But he would say, well, the preamble provides one justification, but not the only justification. I think he's pretty persuasive, so I think it's a neat rhetorical tool, which is kind of all you can expect from a television show that's not going to go into overheads like this. It's better for it.
Yes.
As you skip through some of the slides,
Yeah.
I was able to read fast enough to catch
Sure.
a line or two. And I'm wondering if, of course, it was just enough to intrigue me. Yeah, see, I could catch a sentence here. But I'm just wondering if these slides are going to make it onto your website or somewhere where
Well, there's going to be an article.
more depth. Oh, great.
Oh, I'm sorry. I was trying to find the slide you were talking about.
Oh, yeah.
There's going to be, well, for starters, they're mostly quotes from the court, so they're already there on the website. But there's going to be an article, and the article is going to not be limited by the timing. I hope it'll be limited by other forms of self-discipline, but at least it'll go through a lot more.
Time for one more question? Yes.
What do you see as future cases that have likely success that are dependent on DCB note?
And so I take it you're after the guns. You're not after the broad picture of originalism and these tropes.
I'm interested in both.
I think the big consequence is people say, wow, it's okay to cite law review articles more. This flurry of okay, I'll tell you that, because there's actually another article they're writing about the same topic. So let me first tell you about the really important high-profile ones, and then about other ones that are less important, but at least are less likely. The most important one is, does the Second Amendment apply to the states via the 14th Amendment? The Supreme Court has applied virtually all of the Bill of Rights to the states via the 14th Amendment. It was originally understood, quite clearly understood, as not applying to states, but the 14th Amendment is what that is applying to that. Second Amendment is an exception, Seventh Amendment is an exception, grand jury clause is an exception, but it looks like, I should say it looks like, but it certainly is being litigated. I think probably the 5 justices in the majority would vote to incorporate it, but not at all open and shut. One of the things is we don't know what the justices think about incorporation, because the last hot incorporation debates in the court were in the early 1970s. And at the time, conservatives were anti-incorporation, but what that means today, and liberals were pro, what that means today, not just in the context of this particular right, but in the context of broader thinking about that hard time. So that's the high profile. Here's a second one that's not quite as high profile, but also pretty important. What do you do about guns in public housing? There's a challenge right now in San Francisco to the ban on any kind of gun, not just handgun, but any kind of gun in public housing. I know there's a dispute under the state constitution here in Utah about possession of guns on the university campus property, but I think there's a similar question about what happens if there's university housing, there's student housing, or faculty housing. So that's analogous to the question of the First Amendment context. What power does the government as owner of property have to say, look, we're not going to throw you in prison in general for saying things out there on your own property, but you can't say that on the outside of our bus or in our building hallways. Or what if we were to say you can't say certain things in public housing, because it's ours, and we get to control what is done there. So that, the question of government's proprietor is going to be very important in people's lives. Here are a few things that are not on people's radars, but are pretty important. NRA is filed suit in Washington State against the limitation on ownership of guns by non-citizens. Federal law actually allows non-citizens or permanent residents to have guns. Some states, including Washington, by kind of executive action, which seems inconsistent with state law, but the executive action there, do not allow it. Guam, interestingly, doesn't allow it either. What's important about it is that Guam doesn't raise the incorporation question. It's a federal territory, federally controlled territory. So that's going to be a question about citizens. Safe storage laws. To what extent is the requirement that you keep guns locked up, either in general or when you have small kids around? To what extent is that just a minor burden, because you can unlock it if you've got a combination lock in a few seconds, or a very major burden, because those few seconds could make the difference between shooting and being shot. And one last one that's worth noting is open carry. Scalia said, well, concealed carry bans, those are traditionally recognized, they're okay. But what about open carry? What if somebody really does want to, despite the unwelcome attention he will get from many people, including the police, walk down the street with a gun, preferably loaded, on his hip? In some states, it's perfectly legal. In other states, it's legal, but only if it's unloaded. In others, it's not legal at all. So that's another round of challenges. That's not
Thank you very much.